So you went to the mailbox expecting something from Publishers Clearinghouse, and instead you got a jury summons. What to do? I'll tell you. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. If you were hoping I would tell you the super secret ways to get out of jury duty, that would be incorrect, because I don't believe people should get out of jury duty. In fact, I got tapped for jury duty exactly one time in my life. One time, I went there and the darn case had settled before I could actually even be interviewed to sit for a jury. As a trial lawyer, I would love to have sat for juries so that I could sort of figure out how they think. It's the one thing I can't tell you about because I've never been on a jury. But the fact is, we need juries and we need jurors and we need people who can be fair and open minded, not somebody who has their mind already made up before they come in the jury box, and not somebody who is unwilling to consider the possibility that just because the police arrested somebody doesn't necessarily make them guilty. I think we all learned in the Karen Reed case that that's not the case. And yeah, serving on a jury can be a long and boring process. The days can be long, the benches can be hard, and a lot of the courtroom antics are just not antics at all. There are lawyers going, "Do you remember what happened on July the 3rd?" And they speak in a monotone voice, and you feel like you need toothpicks to hold your eyes open. It can be a boring experience, but we need people to do it. And there'd be nobody better than my people here on this channel who are interested in the law. And so I'm not going to tell you how to cheat the system. What I am going to tell you is what to do. Now, generally speaking, if you get a jury summons, in most counties, you have somewhere between a 1 in 6 chance and a 1 in 20 chance of getting on the jury. It depends on how many people they summon for a particular jury. Now, if you've got a fender bender car wreck case where someone is complaining about neck pain and may need to have surgery, that sort of thing, which could be a relatively high dollar claim, but probably hasn't made it into the news, that's a situation where they might summon as many as 70 jurors. And the reason they do that is because there'll be people who know out of the group that they summon, there'll be people who know the plaintiff, there'll be people who know the defendant. There will be people who passed by that wreck on that particular day and may not want to offer their opinions. There could be people who are absolutely against lawsuits. There could be people who believe that there's never been a defendant that wasn't guilty of something. The mix of people is such that with good voir dire, they can go through that panel of 70 people and figure out who can be a juror in the case and who can't. And so, one of the things that's important is to show up on the date and at the time that is appointed on the jury summons. And one of the reasons it's important to show up at that point is because there is a briefing that you get about what your job as a juror is. And you don't want to miss that because it actually does have some helpful information. And then once that briefing is done, they send you into the courtroom for voir dire. And in voir dire, you can participate as much or as little as you want, but it's always better to participate more. And if you really truly want to get out of jury duty, don't say a word, because you'll be flagged by the parties as somebody who maybe not be interested in helping either side. And it usually people who don't say anything are too dangerous to put on the jury, simply because if they don't respond to the questions, if they don't raise their hands, if they don't offer some tidbit about themselves, they probably are not there in good faith to be a good juror. They are just there because they got a summons that said they had to be. So that's my advice. If you really don't want to serve, you can do that, but it's not the right thing to do. The right thing to do is to help out your fellow brothers and sisters out there who have problems, who have complaints against other people, or who have been charged under the criminal law and may, in fact, be innocent. And it may be up to you to say that. So, once you get into voir dire, what do you have to do? Well, normally the court will start voir dire and they'll say, this is a case about car accident, or this is a case about an assault at a nightclub, or whatever the case is really about. The judge will give you what I would call the elevator speech about what the case is. And then he'll tell you that the plaintiff is over here represented by so and so, and the defendant is represented over here by so and so. And as a result, these are the lawyers who are going to have to ask you some questions to find out if you're the right person to be on this jury. Now, just because you're not picked, I don't want anybody to feel bad. Judges always say that. And people who are sitting in the panel go, are you kidding me? I don't want to really be here, especially not for $6 a day. In Missouri, that's what jurors get for juror pay, $6 a day. Wow, it'd take you a long time to save up for a sandwich, wouldn't it? Anyway, the long and short of it is that that's essentially what happens. You get asked a bunch of questions. And I've gone through my voir dire on this channel once before, but generally what I start out with is, why are we here? So I talk about what happened. There was an accident. Does anybody believe that accidents can be caused by something and that they're not just something that happens? Most people raise their hand. Does anybody believe that accidents just happen and they couldn't be prevented? And people will raise their hands. And I would ask something to the effect of, well, would you, if the evidence showed that this accident was preventable, if somebody did something to prevent it, would that change your mind? Would you be willing to consider that evidence? Basically, what you want to do is keep telling them over and over what you want is a fair and impartial jury. And that's what they will say over and over and over again. Now, in Missouri, they do it one way. In other states, they do it other ways. But in Missouri, in order to prevent claims of juror misconduct, one of the things that the lawyers will have 24 to 48 hours before the case goes to trial is a list of all the people who will be on the panel. And what they will do is they will sit down with all of the office staff and say, okay, everybody take a list here and go through and mark anybody you know on this list. And usually there are 10, 15 people that people know. This person's a good person. You don't want this person on your jury on a bet. Those are the kind of things that get written down on those jury lists and then combined into a master jury list so that you go into court as a lawyer with as much information about these people as you need. We take it even a step further. We go through the court system. The court system in Missouri is accessible by pretty much anybody. And we go in and we look for the names of the jurors to see if they've had any bad interactions in the law. You'd be amazed at what people will not disclose during voir dire. For example, somebody who has been in a car wreck and brought suit in a car wreck, sometimes they won't mention that. And they'll claim later, oh, well, I just forgot about that. But the fact is, they did actually omit that. And as a result, they're a suspect juror now. So you have to be able to identify that before the close of voir dire in Missouri so that it can be fixed before the jury is actually impaneled. Most other states, I don't think, do it that way, but I think that's the right way to do it because unfortunately, people do lie to get on juries and they do lie to get off of juries. But basically, just like you were a witness on the witness stand, you tell the truth. If you really don't believe that people ought to be suing, you need to say that. And If you don't think you can be fair to somebody who has been injured in an accident and is seeking compensation, you should say that. If you feel like you're generally against the principle of people suing, but you can be fair, then again, you can say that as well. I really don't like the idea that people sue one another. I think it's a cash grab, but I'm willing to consider the evidence and follow the law. And that will more likely than not satisfy the judge, even if it doesn't satisfy the plaintiff's attorney in that case. And similarly, if you have a real grudge against a particular defendant, maybe for example, Ford Motor Company is being sued for something, and you have a real grievance with them because you bought a Ford truck and it didn't behave right, and you could never get any satisfaction, and you really just don't like that brand. Again, it's not the place to take out your vengeance because Ford deserves just as much of a fair jury as does anybody else. And so, if you really don't think you can be fair, pipe up and say you can't be fair. Now, at some point, and Gordire can last a long time, it can last 2, 3, 4, 5 hours. I've had them go for 4 hours in my own cases. At the end of the voir dire, what will happen is every juror gets a number when they come in, and all of the all of the statements that have been made in voir dire have been written down and they've been recorded. And so now what happens is the plaintiff gets up and says, "Judge, I want to challenge juror number 31 for cause." Okay, what's the cause? Well, he said he couldn't be fair. And maybe the defense says, "No, no, no. He said he could be fair. He said he just didn't like plaintiff's attorneys." But he said he could be fair. The judge will figure out whether or not, and he will look at his notes and think, well, yeah, the guy really did say he couldn't be fair. So maybe he strikes that juror for cause. And as a result, that juror's not going to have to serve. And the plaintiff goes through their list of people that they want off for cause. They don't get everybody off for cause. They get probably 20 to 30% of the people that they've identified as being a problem juror. If they can make a good case for getting them off the jury, that's what they do. But what they can't do is have all of the Hispanic people pulled off the jury, or all of the black people pulled off the jury, or all of the Catholic people pulled off the jury, because anything that you would get in trouble with for discrimination, you can't do that in a jury either. And so lawyers know that, and they know better than to do that. Then the defense gets its opportunity to challenge a set of jurors. They challenge those jurors. The judge makes decisions. And now the judge says, all right, well, who is the first juror up in the pool? Well, that's juror number 6. Okay. Is that one going to be okay for the plaintiffs? Yes. Is it okay for the defendants? Yes. All right. Juror 6 is seated. What's the next juror? The next juror is juror 9. Okay. Defendant, plaintiff, is that one okay for you? No, we're going to exercise our peremptory challenge here. Okay. So juror 9's off. You go to juror number 10. Is juror 10 okay? Yeah, it's okay for the plaintiffs. We like juror 10 and the defense. And the defense says, no, 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 we don't like juror 10. We're going to use our peremptory challenge. So each side gets somewhere between 3 and 6 challenges that they can use to take off anybody that they don't like. And generally speaking, the higher your juror number, the more likely you are to be excluded in the selection process. The jury will be seated. There'll be 12 jurors and 4 alternates. The jurors, at least in Missouri, remain the jurors during the entire case, unless one of them has to be excused for being sick or something like that, or misconduct, in which case one of the alternates is input. And then once the alternates are selected, then the trial will begin with opening statements. So it takes a little while to get through that. A lot of times you do jury selection on Monday and the actual trial evidence doesn't start until Tuesday. But if you get a juror summons, please show up. Do your civic duty. It's the right thing to do. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.